অডিওটা অন করে দেবে, অডিও। lordship list on the first day of this circuit, and Milord had passed an order that there is an application for
That is to be done by a single bench.
for limitation pending. But Milord, the limitation application has already been decided and disposed of.
Okay. Then order 41.
My lord, may I mention, my lord? May I mention, my lord, item number 59? This
Yes.
matter was taken, lordship, may I kindly remember this matter, my lord, regarding, my lord, 20 lakhs rupees, my lord, check, my lord, pertaining to a deed was not paid. My lord, accused opposite party, my lord, took time, my lord, yesterday to take instruction. Now, my lord, today I believe, my lord, lordship is taking up, my lord, from item 65.
Yes.
So if your lordship
Don't
can
worry,
fix the
I will
matter,
go back. I will go back on Monday. Don't worry.
my lord, my lord, my lord. Otherwise, my lord, lordship, fix the matter, my lord.
Anyhow, don't worry. Don't worry. Don't worry.
Your subject to your lordship kind sanction, may I mention, my lord, item number 100 before your lordship days list.
Yes.
This is there is some urgency, my lord. Would your lordship kindly take it up today, or my lord, any day your lordship should Well, this is my lord.
No, we will be taking up. Don't worry, Miss Maiti. We will be taking up applications in serially. We may reach even today. Don't worry.
As your lordship, get to your lordship.
My lords, may I have my lords kind leave, my lord, with just kind leave of Justice Sinare. My lord, may I mention a matter before Justice Tendon? My lord, it's a principal bench matter, my lord. My lord,
Then let me come back to the principal bench. Don't worry.
The difficulties, my lord, the
No
review
difficulty.
application of Charu.
No. Let us come back to the principal bench. Come on Monday. Yes.
As your lordship, please, my lord.
Yes.
Item number 1.
এইসব জিনিসগুলো মানে রোহন গুলো সব শুরু করেছে হাউ টু ট্যাকেল দিস সিচুয়েশন সেটা আমি বুঝতে পারছি বাট এটা তো জানা উচিত অর্ডারের ডেটটা 25 হবে সার্ভার হয়েছে তবে দেন তুমি কেন দিয়েছো না ওটা লেখো এই একটা কাজ করো স্যার এই
I have the valuation, Lordship. Its totals amount to, Lordship the other day has instructed me to bring the valuation, market value. The totals stands at around 87 lakh 7,491 rupees.
How much? How much?
87 lakhs, comprising of entire building. It totals around 87 lakhs, 7,491 rupees, if I'm not wrong. Yeah, 499 rupees.
Why it was called? I just forgot why I said so.
Lordship, because in order to ascertain the market value of the entire property, of the property in question.
Oh, this is the case where both of you wanted a permission, minor,
Yes, Lordship.
to sell. Entire property is valued at?
The property in dispute is valued at of the three shares. They are total around 87 lakh 7,491 rupees of all the three shares combined.
Okay. Why the court has rejected it?
The court has rejected, saying that the mother has got her own share, so she should sell some her portion. But
Why this order of FMET 18 of 2023 is here?
Lordship, I had given it the other day for your Lordship's perusal. I was referring to it.
Okay.
It was a similar order. I was relying on that.
From the law, that act. Last time you just gave me that book.
So basically, there is a property. Husband is property, that we go to only the mother that we to
Section 8, Lordship. Section
legal necessity that they were so difficult the sales should come below the
Yes, section.
Section 8, Lordship. Section 8 of the Act.
or of natural for the benefit of or for realization of the benefit of the we part interest
Where is the pleading which you have done? What is the necessity of seeking permission?
Lordship, the necessity is that the petitioner, that is being the mother, she is unemployed, and as such, it is not possible for her to maintain the expenses of the child. Her father has passed away, so in order to secure the future of the minor, in order to secure and she also studies in a reputed school in Siliguri. I believe it's Chandrasekhar Bhaktinagar. So in order to secure that, she is willing to sell off the property, and she is also willing to indemnify the minor and make a fixed deposit.
No, that's true, but the other co-sharer, they have given a no objection.
They have given a no objection, Lordship.
So they will sell jointly to.
Yes, they will
the
sell
entire
jointly. I
property.
believe they have the.
And who is in
Lordship,
possession? Who is in possession of the property now?
Lordship, the possession is in the OP herself. OP herself, but the petitioner also visits sometimes. That's the
She
situation.
herself is a sister.
Sister-in-law of the petitioner.
And sister.
Lordship, as per direction, I have submitted written submission, behalf of the respondent, Lordship. She is willing to sell the property.
This is not a written submission. It should be in the form of an affidavit. This is not the way to do it. Written submission. Who has signed? Deponent. How the deponent will without an affidavit? You have to do it in the form of an affidavit.
My lordship.
This is not a written submission, sir. This is not a practice in the High Court. File it in the form of an affidavit. Let us, we are keeping this matter on Monday. Let her swear an affidavit and file on the Monday. We'll pass the order. Only thing is, so far as a minor share, you will not sell it below the value of this, market value of this property.
Yes, Lordship.
And the minor shares will be invested in the fixed deposit.
Yes, Lordship.
And the interest component can be utilized, but not the principal.
Lordship, the interest, I'm sorry, Lordship, I did not get the last part.
Only the interest component which would come from that fixed deposit that can be utilized by you for the benefit of the minor,
Yes, Lordship.
but not the principal amount.
Yes, yes, okay.
It's Monday, not today. Yes.
Get lordship.
Get full, Lordship.
Until majority.
Until majority.
Until she attends.
That until she attends majority. What is her age now?
Her age, she was born in 2018, 6, 7 years, that's her age right now.
So it's a considerable period.
Great.
Yes, what is this?
One more indulgence if I may.
Yes, what?
No, Lordship, no.
Addition of criminal activity.
On the list?
My lord, I am for the petitioner in this case, my lord.
Yes.
We are not visible.
My lord, this is in
Why Union of India?
my lord, that was an appeal against the acquittal. My lord, the leave was granted by this honorable court, my lord, by its CRM SPL number 7 of 2024, my lord.
Audio.
The order sheet.
The order of the CRM SPL, where is the order? Where is the order? Can you hear? Where is the order?
Annexed, the certified copy of the order is annexed with this application, lordship.
Where is the application?
After the page number 7.
The application ta kothay?
After the page of.
Sir, we do not find any application here. Application আছে আপনার কাছে? কোথায় আছে দেখো?
Application has been allowed, lordship.
There is no application filed by you, sir.
Lordship, the application was allowed and the order sheet is annexed, my lord, in after page number 7. The certified copy of the order has been annexed, lordship.
Where you have annexed? We have a memo. We have only a memo of appeal before us.
Yes, lordship. No, CRM SPL 7 of 2024 that was allowed by His Lordship Honorable Justice Joymallo Bakshi, my lord.
Where is, I do not find this.
The internal page number 7 of this petition, after that the original certified copy is annexed.
কি বলছেন উনি দেখো তো ভাই আমরা তো পাচ্ছি না let them so that is a irony when you appear virtually and you do not know what is the document.
There is no junior.
কোথায় আছে? Oh. Sir, tell me that how an appeal can lie in the form of an application, sir.
Pardon, Lordship?
I have seen the format, how the appeal lies in this format. At the very first, you have said that an application under section 378 1B of the Criminal Procedure Code. Is it an
My
application?
lord.
So tell me. Sir, come, you are the
Lordship,
advocate and record, sir.
yes, my lord.
You'll have to make a correction,
Uh,
sir. You can't sit in your comfortable atmosphere and then argue the matter like this. There are series of serious defects. Those are to be cured.
Lordship, then kindly fix the matter on Monday, my lord. I will be there, my lord, physically.
Come, you'll have to do it.
My lord.
Yes, not today.
My lords, I'm for the appellants. My lords, this is a bail in the form of an appeal under the NIA Act.
Bail in the form of an appeal.
My lords, it's an appeal, but
Uh-huh.
a bail application majorly.
But this requires first an admission, then the suspension of sentence you want.
No, my lords, it's not a conviction case. It's
So,
at the stage of trial at the moment, my lords.
so then how the appeal lies?
My lord, section 21(4) of the NIA Act says that.
Sure.
Yes.
Yes, please.
I'm representing the respondent, National Investigation Agency, against an order of bail rejection by the lower court and
Just
appeal-
let me first ascertain whether the appeal lies or not.
21.
21 part 4.
আমরা আমাদের প্রশ্নটা করি bail is an interlocutory order. What is your submission? If we pose this question to you, I will deal with this.
Only look at it because it says that it must be a final order. It should be a final order. Whether this order is a final order,
My lord, the
I am
lower
just asking.
rejection from the lower, the order that I'm appealing is a rejection from the lower court and it's a final order in that, for that respect. An order dated 5/10/2024 is what I'm challenging.
It is filed within that particular proceedings.
Yes, my lords.
Is it separately registered? Or it is only an application within that particular proceeding?
My lords, and it's within the same case.
If that is within the same case, whether it will come under the purview of interlocutory order, like an injunction as you saw in the civil court. His suit is filed and application for injunction is filed. Injunction is granted, refused or what? Then it is an interlocutory order. Unless the appeal is provided, that order is not amenable to be appealed. Here the section 21(1) says that notwithstanding anything contained in court, an appeal shall lie from every judgment, no difficulty, sentence, no difficulty, or order. It is appellable, but qualified by not being an interlocutory order, means the final order. So that's why I'm inviting your attention whether this order can be termed to be a final order or it is really an interlocutory order. I'm just asking you.
My lords, as with my due limited knowledge, it is a final order.
How?
And this is the
Now you'll have
process
to-
how.
Now
It
you
has
have to
been-
then satisfy that it is a final order. Because if there is a separate thing which is there, then in that event, one has to understand. There are definition of the interlocutory order, there are a definition of the other orders.
My lord, can I come back on Monday then for, with a clearer understanding of this and
If it is separately registered, I can understand because it brings into that particular miscellaneous case or a miscellaneous application. Whatever.
During trial or going that file, that was.
So within the main matter to be filed, I separately registered now. Your
There is. Unless there is any other business that contrary to that.
absolutely.
What is your submission, sir? Whether is an interlocutory order?
My submission is that against an order of rejection of bail by the lower court, an appeal is provided under section 21 of the National Investigation Agency Act.
I do not find this qualification. This
There
qualifies.
there has been judgment by
Show us. That is what we really. That will help for my understanding.
দুটা কপি আছে ওটা এটা দুটো decision of our honorable division bench of
No, I'm just asking because obviously there is something which is playing in my mind. That is what I really want to know. So can you show me that where this point has been taken? It is saying that the appellant has been convicted by the trial court in such police case. So if it is a conviction, then it is a sentence. So appeal lies, no problem, sir. I am talking about something differently, sir. And you are referring this because of the delay.
yeah, for the delay.
I'm again saying
I
whether appeal lies because it says it is appellable against an order which is not interlocutory in nature. So what should be the definition given to an interlocutory?
I understand.
That is really because it is against an order. It is
Against
not a
an order.
judgment, neither a sentence.
And these two cases relates to sentence.
Sentence. So no problem. But the definition is very. Look at it. Yeah, please look at 21(1).
Now, Your Honor, your lordship has rightly pointed out.
This is
And
what
both this decision is in regard to sentence.
it says. It shall lie from any judgment. It's not a judgment. Sentence. It's not a sentence. Or order. Yes, order is appellable, but qualified by not being an interlocutory order. Why this word is used? Not being an interlocutory.
my lord, has my lord seen part 4, 21 part 4, subsection 4?
Subsection 4, yes, notwithstanding anything contained in subsection 3. Subsection 3 says, except as aforesaid, no appeal or revision shall lie to any court from any judgment, sentence, or order, including an interlocutory order of a special court. No difficulty. So, revision is also barred. Interlocutory order. Now, 4 says, notwithstanding anything contained in subsection 3, means this is an exception to that. An appeal shall lie to the High Court against an order of the special way, granting or refusing it.
Yeah.
This is what, yes, you are. That's
Grateful, my
sorry,
lords.
sorry. Thanks to point out.
Grateful, my lords. My lords,
Who
at the,
Yes.
my lords, at the outset, I will urge my lords to condone my delay of filing of this
How many
appeal.
days?
34 days, my lords.
My submission is that
My lords. My lords,
What do you say
there
about
has
the
been an
continuation,
adverse
sir?
order. My lords, there has been an adverse view taken by our High Court in this
What?
view that the delay cannot be condoned.
Why?
However, beyond 90 days, because the act says.
Outer limit, where is the limit set for condoning for
Section
21(5). However, my lords, recent.
Just,
Section 5. Section 5.
no,
Section
5,
21.
21
subsection 5.
subsection 5.
Oh, sorry.
You are referring a section in such a unique manner. I am not accustomed to it. Every appeal under this section shall be preferred within a period of 30 days from the date of the judgment. Provided the High Court may entertain an appeal after a earlier 30 days is satisfied the section. Provided no appeal shall be entertained. Oh, okay. Then, madam, how can it be
My lords, so what
after
happened?
90 days?
So my lords, what happened the last time?
Your
I filed
second
an
decision, is relevant.
my lords, if my lords will see
Again,
my
the
CRAN
copy.
application 1, CRAN 1, the limitation application that I have filed for condonation.
Madam, is it an appeal filed beyond 90 days?
Yes, my lords.
Correct. Now tell me.
Now, my lords.
Now
what-
I'm giving you.
Yes. My
I'm
lords,
asking you a question.
so my
Wait,
lords,
wait. Have patience. We have a patience to listen to you. You must
Apology, my
have,
lords.
you must reciprocate it. When an outer limit, the principle of law is when an outer limit is provided in the statute beyond which the power of the court is fettered, can the court go beyond it? That's the first question you have to answer.
so my lord, this question is pending in the Supreme Court, my lords. My lords, it has, if my lords, we come to the page 11 of my CRAN application number 1,
Page
11, my lords. So, my lords, an appeal was filed from a writ petition filed in Delhi High Court and the
11.
Supreme Court for the time.
11.
Yes, ma'am.
Just one. Yes.
My lords, if see paragraph number 3rd,
Two.
till the next date of hearing, appeals petitions preferred by the accused victims will not be dismissed on the ground that delay cannot be.
Page
11.
Page 11 is our High Court judgment.
No, page CRAN 1, my lords.
Oh, sorry, I'm
CRAN
looking. My bad. Yes.
Page 11. It's an order dated 4th February.
Just. Oh, no. What has happened? It was transferred, this order at page 7.
Yes, ma'am. And thereafter,
There-
this order.
Just. Page 7 order indicates that the matter is pending before the Delhi High Court on this point.
Yes.
The writ petition challenging that provision of the act was filed before the Supreme Court under Article 32. The apex court in this order says that since the Delhi High Court is in session of the matter and is about to decide the same, so let all these writ petitions be also sent to Delhi High Court so that they can decide it. This is what the first judgment at page 7 and 8 says. And these writ petitions were set at closed. And then the second interlocutory IA was filed therein, as it appears, which were listed on 4.2. And this IA, this order is passed. no adjournment should be granted. Appeal preferred will not be dismissed on the ground that the delay cannot be condoned beyond 90 days. The High Court may proceed with the writ petition. Parties will file written submission not exceeding 3 pages along with the judgment within a period of 10 days from date. So now this period of limitation or ground for delay is set at rest. And this order was passed on 4th of but how this matter remains pending? What happened on 24th?
Why not? I looked up online. I could not find any orders passed on that date. So maybe it was not taken up on that date.
What to do, sir?
I would like to submit that the order, that the decision which they have referred, it states till the next date of hearing, appeal or petitions preferred by the accused/victim will not be dismissed on the ground of that delay cannot be condoned here. So it has not been disposed of. It's still pending.
So till the next date of hearing means unless that date comes, it has not been listed for hearing.
No, and I would like to further submit that the division bench of our honorable court, comprising Justice Devanshu Bashar and Justice Sabar Rasidi, has categorically held that the provision, the word used, shall, in section 21, subsection 5, is mandatory in nature. And the
Sir,
Kerala High Court.
Probably you could not go through this order at page 11. Sir, a judgment.
I have gone through that is lying before me.
Have patience.
Sure, definitely.
The judgment of the division bench was passed in the year 2023. And this judgment, this order is passed just on 4th of February 2025. Superseding this order. So if there is any contrary decision which is already operating in the field, what appears from this tenet of the order is that this matter is really a subject matter of writ petition before the Delhi High Court. It has not been decided. The Supreme Court, correct, the Supreme Court has said that so long that is decided or till the next date of hearing, don't dismiss any matter on the ground of delay. If this is a mandate subsequent thereto, then the judgment or order of the Supreme Court will be binding on us, then the coordinate bench decision, Article 141 of the Constitution.
I would like to further refer a judgment of Supreme Court. It is, of course, it is come in 2024, decided on 5th April 2024. As because our Honorable High Court said that the provision is mandatory, delay cannot be contained.
Correct.
And Kerala High Court was also of the same opinion. But the High Court of Delhi, Mumbai hold that contradictory view. So that matter came up before Honorable Supreme Court. And I would like to refer, there is a divergence of views between different high courts, while the high courts of Allahabad, Bombay and Delhi have held that the 90-day limit is directory. A contrary view has been taken by High Court of Calcutta and Kerala. Now, even the conflicting views of the High Court, that question has to be resolved by this court, Supreme Court. So that question has not yet been resolved.
So what to do, sir? So the question is, again, I am telling you, sir, please tell me what is the proposition of law? There has been a divergence of views expressed or taken by the different high courts of the country. The matter was brought to the notice of the Supreme Court. The Supreme Court decided to resolve that dispute finally, and the matter was kept pending before it. It has not been decided finally. So this diverging views is still operating in the field till it is not set aside.
This is what I am submitting.
Right. Now, in the proceedings, the Supreme Court says that till the time or till the next date of hearing when the matter would be fixed, the appeals on the ground that it is filed beyond 90 days should not be dismissed.
So in that particular case, which has been filed before High Court, it will not be dismissed.
But I do not know because when the matter is referred or matter is taken up by the Supreme Court to decide a larger issue, taking into account the divergent views of the different high courts, then this interim order or this order has to be construed in that perspective. What you are saying that it is only restricted to that matter only, I think one has to understand the tenet of the order of the Supreme Court. Because the Supreme Court would have said that so far as this appeal is concerned, shall not be dismissed. Why? The appeal is before the courts. Why the court says that appeals / petitions preferred by the accused / victims. Kindly visualize both. It's a very omnibus, I would say, very expensive order. It does not restrict to an appeal by an accused. It also engulfs within itself the appeal by a victims. Both will not be dismissed on the ground that delay cannot be condoned beyond 90 days. So that's the order which is operating. I think it is an omnipresent order everywhere, not restricted to this.
With due respect, I would like to submit your lordship that order particularly restricts to that
My
particular
lords,
appeal.
if I may,
Cannot be. Then sir, that appeal must be filed either by an accused or by a victim.
No, that was already pending.
When an appeal is filed, it is filed by an appellant who is either an accused or a victim. Both cannot join in one appeal. Can they join in one appeal? Accused and victim can't. Impossible.
my lords, if I may, the next line, the fourth paragraph, the high courts may proceed with writ petitions challenging. My lords makes it further clear that it's a general.
I understand. It's a general order. What he's saying, that's why I'm just trying to make him understand this. So it's a very general way of expressing that any appeal which is filed either by an accused or by a victim will not be dismissed on the ground of delay.
If your lordship is of the view that it cannot be discussed, my second ground is that this is the fifth or sixth time that this present appellant has.
That's a merit.
Yeah, I'm
That's
coming
a
to
merit. Sir,
I'm coming to
we,
that.
We have not entered into a merit. Because the first hurdle was that it is admittedly whether the court should condone the delay or should not condone the delay.
And I've also given a decision of the Supreme Court which I read early, that there is a diversion of view between different high courts, while the high courts of Allahabad, Bombay, Delhi have held that the 90-day limit is directory. A contrary view has been taken by the High Court of Calcutta and Kerala. Then it says, given the conflicting views.
Sir, I tell you, subject to corrections, what I understand about the law is there are judgments of the apex court, including one judgment which I can recollect is the judgment of Justice S.B. Sinha. There the point arose that the point which has been referred to a larger bench and the larger bench has not decided that point. Then what will be the role of the High Court in this regard? The Justice Sinha's view was that the court should not wait till the judgment is delivered by a larger bench. The court must proceed to decide the matter on the basis of the law which, according to the High Court, is operating in the field.
In that case,
Sir, I am conscious, sir. I am conscious. Here is a case where there is still a matter is pending before the larger quorum or the Supreme Court. Our High Court has already decided it and have said that is mandatory. So that is binding on me. The coordinate bench, it is binding. If we want to take a dissenting view, then we'll have to refer to the matter to the larger court. I understand. But I feel some obstacle when this paragraph is placed by them, which is the Supreme Court judge order on 4th of February 2025. If it puts a fetter in dismissing the appeal, then can we say that what would be the effect? If we say no, we can't condone, that means the appeal is also dismissed.
Exactly.
Can we dismiss? This is what is this troubles us. The only course open is, what I feel is, keeping the appeal alive, but we don't know what will happen. That would not serve their purpose. Because the nature of the order is such, had it been a judgment or a sentence or whatever, the position would have been different. But this is against really an order, refusing or granting bail. Now the question is whether the order is correct or order is wrong. I have to decide the appeal.
The Supreme Court, in that particular judgment which the counsel for the appellant have placed, it further says that the High Courts may proceed with the writ petition challenging the provision of unlawful.
That is where the virus of this provision was under challenge. That it is opposed to constitutional provisions. It is opposed to legislative provisions. This is what the virus was challenged. Test of reasonability, that is the Wednesbury's principles, whether it can stand on that test. So that will be decided in that writ petition. But what you have to say, and that's why we asked whether the matter was fixed on 24, what has happened? He said that there is no information that it was fixed on 24 or 25 or a 26 or a 27.
What is the reason for not preferring within the statutory period?
What is the reason?
My lords, the petitioner's wife, my lord, the petitioner's wife is the only adult person in her house at the moment, and she has 6 children. So she could not come on time. my lord.
That is
That's
not
the,
sufficient.
there's been, and the financial stringency is the main cause, my lords.
That cannot
Very,
be sufficient.
honestly, like 6 children, 3 of them, one is 4 years, 6. And the person is in custody for 4 years, 6 months already. And only on the basis of co-accused statement, and the co-accused person has also died in custody. From whom that, and I'm also on parity, my lords. I'm seeking bail only on parity. Nothing was recovered from me.
How many witnesses are left?
We have examined,
13 says.
now there were altogether 62 witnesses. We have examined 30 witnesses
No,
and we
30.
no,
30.
Okay.
And we are likely to examine to further 10 or 15 witnesses.
my lord, as per my information, only 20 witnesses have been examined since the last proper rejection on merits on 16/5/2023.
20
Other than that-
witnesses have been examined,
And
but we have pruned the list and the
80 was the
expert
best.
report submitted by the experts have already been exhibited. So we have waived the examination of these 8 or 10 expert witnesses.
My lord, another co-accused person on the same standing has been released on bail. He has suffered, he was arrested after this petitioner, after this appellant, and he was released on bail before him.
No, it
And on
cannot.
the last rejection on 16/5/2023, which was decided on merits,
No,
that time the ground taken by them was that he is.
Madam, the court has recorded that the previously all your bail applications were rejected. And the court has said that they did not find any changed circumstances which warrants. Now tell us that when was your last rejection?
My lords, what
And-
happened?
After that, the co-accused who stand on the same pedestal was granted bail.
So-
Whether that is a changed circumstance?
Yes,
Sure.
my lord, so what happened?
Now, if the court is
Ma-
hearing on the merit, I wasn't prepared.
What?
I was just, the case was listed for hearing
No,
of section.
we will keep the point of limitation open. We are just thinking for the purpose of an admission of an appeal.
In that case,
It is not you who have to be heard.
I-
We
I-
will
I
we
just
will
like
hear
to-
you thereafter. Let me hear. Let me hear. The court has said no change circumstance. Tell me when was the last
So my
rejection?
lords, four appeals have been filed by this petitioner previously. The first one was on, the
I
last one
just
was on
want-
20th/1/2025
Yes, the last one
at
was
page 14, mine.
was 20,
20th January 2025.
28th
Yes, 20.
January 2025.
Yes, my,
That was rejected.
yes, my lords.
And then this application appears to be filed before
No,
that.
my lord, it was, no, it was filed afterwards,
This
my,
is the order of 5/10/2024.
my lord, lower court's order of 5/10/2024.
You are challenging this order in appeal, madam.
My lords, my lords, what happened on the last day, that we had challenged an order dated 28/11/2023. 5/10/2024 was not challenged at that point of time.
Please, I understand, madam, I understand. Now, this order is of 5/10/2024. I just wanted to know what was the earlier rejection.
My lords, they come at page 14 of plan.
So
Grant
you challenge the order of 2023.
Yeah, in the previous rejection, yes, my lords.
Did you take a plea of parity
My lords, what happened?
on 20th of January 2025?
My lords, on the ground of maintainability, because that time also the petitioner, the appellant had challenged after beyond the period of 90 days, and this order of Supreme Court was not before us.
Whatever, the court has entertained on merit.
No.
Then page 14.
My lord, at page 14, at the
What?
threshold, it was dismissed.
Threshold it was.
Oh, yeah, same limitation.
Limitation. Okay.
Page 14,
Correct.
threshold. Similarly, my lords, the other order was also page number 13. The other was also rejected on threshold because there was a one document was, one statement was misstated in the petition. In the
No,
appeal.
that is the threshold based on merit or what?
No, no, my lords, not on merit. My lords, it came at page 13, short 2 paragraphs order, not on merits.
When the order of bail granted or a bail was granted to a co-accused whom you consider to be a similarly circumstanced person.
My lord,
Because
at page
when that
number,
order was passed.
my lords, we come at my order.
Please, the order which you claim parity, that order was passed when?
On 31st July 2024.
31st
July 30th, 2024.
2024, it was granted to that person.
Yes, my lords.
When you took out an application here,
16/5/2024 was my previous rejection on merits. Sorry, my lords, I may
Yes.
not have understood something.
16/5/2024
2024,
was your earlier. When you took out this application.
the present application, yes.
When?
When I filed. 9th or 10th of February 2025.
Right? No, this order is of 5/10/2024.
Oh, in the lower court, my
True,
lords.
that
Trial
is what
court.
I am asking
Yes,
you.
5/10/2024.
5/10/2024.
5/10/2024. Yeah.
Did you brought to the notice of the court that this, the similarly circumstanced person has been granted bail on 31st of July?
My lords, I'll
Did
just-
you brought?
My lords, it is not recorded. So,
In your application, I just wanted to know, did you disclose? Oh, this was on 10/9 and 12/9 application. Order says bail petition dated 10/9/2024 of accused Sadiq Mia. And bail petition dated 12/9/2024 of accused Mukhtar Alam are taken up. So these two applications are taken up. While on that day, did you mention you are?
for Mukhtar Alam.
You are Mukhtar. So did you,
My lord, it
in
does
your
not.
application dated 12/9, did you
Claim parity.
avoid parity? I just wanted to know. Sir, this is, I should not say anything, but the member of the bar should read the brief very
No, no, my
carefully.
lords, it does not appear so, my lord.
It does not appear.
from
This is the order
Yes.
itself says
It
that
does
what
not.
is the date of an application. I could get it here for the first time reading.
My apology, my
And this
lords.
is, you are moving and you do not read the brief.
No, no, my apology, my lords. It,
Then you have,
I have-
the court has said no change circumstances. Why? Then you will have to say we are in appeal. Madam, kindly consider. We are in appeal. We are to decide whether the judgment or order of the trial court is factually and legally correct. If there is a factual mistake, then definitely we can interfere. If there is a legal mistake, we can definitely correct. We are asking you, you are arguing on the ground of parity. We are saying that whether you have taken this ground in the petition, have you made an averment? Because this application was filed on 12/9, you are claiming parity on the basis of an order dated 31st July prior to it. Did you ever?
no, my lords.
Have you checked that application?
No,
You
my
say
lords, I have
no,
not
my
checked.
lord.
No, my lords, I have not checked the document
So-
personally.
And then you are arguing. If the court does not find from the petition that you have averred that, can we say that this order is wrong? I am asking. If you do not plead, then why the appellate court will interfere? Why the appellate court will say that he was wrong? For that reason, I am asking. And you are not cooperating and assisting the court.
My apology, my lords. My lords, may give me 2 days' time. Let me come back on Tuesday or Wednesday.
We'll keep the point of limitation open. I tell you, sir, we will not dismiss the appeal, but if we think that there is no merit, then we can proceed and dispose of the matter.
So, next, 4 lakhs on the picture.
My lords, Wednesday, just, Monday will be the, I'll go and check the application in the lower court.
How about Tuesday,
My lords, we keep it on Wednesday, my lords.
Wednesday,
Grateful, my
on the
lords.
prayer of the appellant, Wednesday?
Same for my
Grateful.
knowledge goes, the ground of parity was not raised in the lower court.
You have a copy of the application.
I don't have the order, a copy of the application right
To
now.
us, shows that copy, then it's all right.
At 21/2025, Muktas Alam's, they are also rejected on that.
It's called the next.
Grateful, my lords.
Lordship, and for the appeal, Lordship. Pending for admission of the appeal, no delay, Lordship. Judgment passed on 18th December 2024, Lordship.
What is that? Total or
This is the affidavit of sir.
total or what?
No, Lordship,
You are convicted
Lordship, life imprisonment, Lordship.
for life?
Life.
So POXO.
POXO, Lordship, POXO 6.
Life is
I am for the appellant, my lord. In item number 68. My lord, the appeal is in time. Appeal is against the order and judgment passed by the Additional Session Judge Third Court Jalpaiguri, thereby convicting the appellant for the life imprisonment for the charges 302 of IPC, my lord.
same order admitted. You are refer book. Record be called for. Next.
Grateful, my lord.
69.
Lordship, item number 69, praying for 1 day's accommodation, Lordship.
Any other? Next.
Carefully.
70. 70 copy. 60. No, something.
Is appearing.
67 and 68.
Subhas
And for the
is
state
withdrawn.
in 70.
Yes, madam, you wanted an adjournment.
Monica, yes. Monica,
Your body language
My lord.
suggests that you have come for adjournment.
He's coming.
my lord, in this matter, this has been wrongly listed because the 389 application has already been disposed of, my lord.
This CRAN two
CRA into
of 2024.
grant to is. Key file, আমার কাছে grant to
This is filed on 13th of December 2024.
হ্যাঁ।
No, I did not find, there is the order for listing this matter before the.
No, there is the order.
CRAN one is disposed of, but CRAN two. This is CRAN two, sir.
My lord, order number.
This is a bail application, madam.
This is the bail application.
This is a not bail, suspension of the sentence.
Suspension of sentence, madam.
My lord,
During
kind-
the pendency of the appeal.
Yes, madam.
Madam,
You
this-
have, madam, 430 PNS, madam.
my lord, kindly come to the order dated 25/9/2024.
This application is filed after 25/9/2024. So it cannot be disposed of. This is filed on 13th December 2024. Subsequent to that.
Why, my lord?
Hey,
Same
now,
ground.
I do not know. Look at here now.
Madam,
Please look at this. This is grant to date of filing at the bottom.
It's for what? It is for? 430. It's praying for suspension of sentence.
True. This is the second application. First application was dismissed.
You took years.
Was dismissed. Was dismissed. Dismissed on merit. Second application হবে নয় না তো তো হয় না তো second application
There is no provision for
second
389 on second application, madam.
Show us. Satisfy is taking a preliminary objection.
There is no bar.
He says there is no provision.
To my
You
little
say there is
understanding-
no bar.
Worship, to my little understanding, there is no bar to file first time or second time or third time. Every minute of a accused person who is in jail is very relevant, and every day I can file.
Every day you can file a 389 application.
Not only 389, 389 also.
No. Change of circumstances also. On merit, it was discussed, my lord, disposed of, rejected on previous official, pertinent based of this honorable court, my lord.
Now, when you say the second application is not maintainable, that's why I asked.
My lord.
It is not entertainable is a different thing. You
Well-
can say on merit that it has already been decided earlier, so it should not.
My lord.
But maintainability is the main issue. So is there is no bar?
No bar.
Yes, sir. Why?
We have to find out.
But kindly this is Monday, my lord.
Where is the provision
389.
of PNSS or CRPC?
CRPC.
Created CRPC. And 430, my lord, PNS.
CRPC, civil lawyer. 389.
Lordship.
The first application, it was filed for 389.
Yes.
That's good.
Yeah, that is.
এটা বোধহয় আমার মনে হচ্ছে প্রিন্সিপাল সিং তো ডিসকাস হয়েছে না
I do not find any fetter. Sir, in 389. That they cannot file an application. Yes, sir, I do not find.
Fix it on
I do not
Monday,
find.
we'll come back with that, if we find some.
Sorry?
But we are also confused.
This is a very unique way which I have experienced for the first time. That adjourned, let me find, if we find some judgment, if you do not know whether there is any judgment, how can the matter be adjourned? And the language of the section does not create any bar.
Well, give us half an hour time. We just.
What? I do not think the principle of res judicata or a principle of estoppel will come into play in these cases. No. So, if it does not, then why not the second application? Only thing is, if it is misconceived, it has to be dismissed with certain observations.
We have not seen it. So if I've seen anyone.
Yes, sir, what change circumstances from 25/9 to 13/12? For these 3 months.
Lordship, actually, at the time of disposing of the first application, it was the honorable coordinator bench did not enter into the merit of the case. And he
Did not enter it. I have find there is some finding which is there. Paragraph 4 is very clear. That's the finding on merit.
Lordship, I beg your pardon. Lordship, actually, the victim, accused person is a lady, 54 years of old.
Whatever,
And
if she is found, she is convicted. If there is a very, very serious allegations, serious incriminating materials which is found there, why there should be such a,
The accused person appears that the
can this point was available to you when you moved first application? That she is a lady?
He was a lady. That he was also available at that time.
Lordship.
Then
He's in incarceration since long. Lordship.
I think if it is rejected on 25/9, now long cannot come.
25/9.
Only she has sentenced more than 3 months, 3 months more. Nothing more than, and the life imprisonment is inflicted upon, what more?
so you have to say that there is no chance of early hearing of the criminal appeal. There is.
No, he is otherwise ready, everything has been ordered.
Everything is ready.
So,
We are going to hear. You have to take all this plea here. That there is no chance of early hearing of the criminal appeal or something like that. But that is also not correct so far as your factual aspect is
just
concerned.
imagine, read the question.
People have been prepared and served upon and served upon the state.
Therefore,
And on
and the
and
learned
Landed has not yet collected.
just imagine, if you are at fault, then you wanted.
Yes. Landed has not yet collected the paperwork from the department. You did
That's
not
a-
collect.
That's a lapsus on your part, negligence on your part. And you are taking advantage of this. Can we take it? No. Can we make some observations?
I am not well today. I am not well today, my lord. Since last night I came home from hospital at around 4 o'clock in the morning, my lord. I am not feeling well.
Everybody who is present in the court will say that you are not well.
My lord, I am not well. See, I am just, I came here because briefs were lying with me and my.
Are you pronouncing vain or well?
Well, my lord, I am not well today. One day accommodation, I will come. And I will come prepared with.
On a lighter note. Yes, can we
My lord, I'm praying for one day accommodation.
Why, madam?
My senior will appear in this matter. He is before principal bench, my lord.
The Poddar is in principal bench. What are you talking? Never goes to principal bench.
Mr. Kumar Shantanu, my lord. He is before
Advocate,
principal.
where is the advocate in record, Mr. Hillul Saha Poddar?
This is appeal and we are for bail in connection with appeal.
And that time.
Lordship, I am for the respondent in this case, my lord. And this case,
He's asking
Finding
for
my
time.
lord.
Not today. Next.
Grateful, my lord.
Your Lordship, the advocate on record, Mr. Abhishek Sarkar, couldn't make it to the court today due to an emergency medical reason. So therefore, the council would pray for not today.
Yes, next.
It is the same for this item number as well, 74.
Yes.
Grateful, Your Lordship.
For special legal section 374.
Special, yes, for 75.
my lord, I am for the appeal, my lord. And my lord, kindly give us one day accommodation, my lord. I'll be present before your lordship physically, my lord, on Monday.
Yes, 76.
76, Lord, sir, I am praying for one day accommodation.
Why? Anyhow, not today. Next, 77.
77.
Evening crossover call. 70. Do the graduates. It's district court the thickest.
Amicus with
To the doctor. And this is the death reference. Next. You must appeal. None appears. Last officer also.
minor beginning. I don't see the part of it.
There is, anybody knows, him, Hong Mitro? The Bar Association Circuit Bench of High Court at Calcutta.
He is from this local bar.
Where is he? Where is he? Why is he not appearing? Last occasion also he does not appear.
I will ask my junior please.
He's not today, we are keeping it. Tell him. Let's call the next.
And for the appellant, but in this matter, I have gone through the record and there were two defects. One is there is delay of 43 days. And another one is we did not file the leave to appeal because we were not
We
party.
were not a party, yeah.
But in the meantime, we have filed the can one with prayer to leave us grant a leave for filing an appeal. But section 5 petition has not been filed yet.
Why?
Kindly allow us by
What allow us what?
within Wednesday we will file the condemnation appeal.
Though the application seeking leave to appeal is filed. But
appear in this matter due to some personal difficulty could not appear today. Kindly make it more clear.
next.
Great.
Everyone, question, I am for the private respondent number 7, Lordships. I am facing the problem, your Lordships, since 2018, your Lordships.
But this Devotee Dor again.
Lordships, DSG Sudipto Majumdar is appearing particular in this case, your Lordships.
For the appellant.
Yes, Lordships. And your Lordships kindly see from the 2018,
Then he's
3
opposing.
times.
Then opposing, then we'll have to dismiss the matter.
Lordships, please then it will be the 3rd time dismiss the matter, your Lordships. They have only dragged the matter, your Lordships.
What is the matter?
Lordships, the private respondent filed a writ petition in the year 2018.
Yes.
And thereafter, one order has been passed by the Honorable Justice Sompa Sarkar and disposed the matter with the writ petitions.
No, please tell me what was the cause of action?
Lots of cause of actions, the respondents encroached totally encroached by the particular appellant.
What appellant in what for you filed a writ petition? That you alleging that the appellant have encroached upon
Yes,
your
Lordships, my
land.
main egress and ingress. I'm unable to enter my promise. Then thereafter, your Lordships, the one direction has been given to the SDO and DI to remove the encroach. And thereafter, against that read, they have preferred and again read before the Honorable Justice Vivek Chaudhary, and he also confirmed that order. And thereafter, they challenged that order.
In the appeal.
Yes, Lord. And thereafter, they each and every time, your Lordships, I have.
It has not been removed as yet.
No, your
Have
Lordships.
you filed a contempt application?
No, it's because the matter is pending, that's why.
No, that is not. There is no stay order.
And thereafter, they prefer this appeal that there is.
But there is no stay order. Is there any stay order in the appeal?
Yes. No stay order. In spite of that, they actually, when my client had been to the office, they stated when the matter is sub judice before the honorable
No, you
court.
could have, if the demolition has not secured, then you have a remedy.
If your Lordship see the Lordship, the conduct of the appellant, your Lordships.
Please consider, sir, you consider the law first.
Lordship.
Advise your client accordingly.
Pardon me, Lordship.
Advise your client accordingly.
Actually, my client is.
None appears in support of the appeal.
Earlier,
Class application.
3 times.
Yes, call the next. Dismiss করে দাও, আমি যাওয়ার
তবে আমি তাতেই ডেকে যান স্যারকে
Yes, yes.
আর স্যারকে জড়াবেন
Oh, then 82 here. 82 has come. What is this application? Can to? Is a? Stay. Donation has been done. Just give us. Where is the special bench judgment to which I was a party? Where is that judgment? Have you gone through that judgment?
Yes.
So where is that? This is one of the points
Yes,
which
one
was
of the
the
point
point
of prior
That
permission.
is why you.
And our second point is that the university from which he got the PG degree, postgraduate degree, it was not recognized. As a result, we have annexed the document. Secondly, it was a state recognized university. It was not permitted to.
No, first point, we have to see that if he has acquired a higher qualification. If he has acquired a higher qualification in 2013, after that, Control and Expenditure Act has come into play, whether is entitled to a higher scale of pay. I don't think so. We have decided against you, against them. And second thing is recognition of his degree.
Yes, we have annexed the document in the state application because state was not represented.
Who is appearing for them?
Mr.
Yes.
Mr. Vikramita Ghosh.
Lordship, in this matter, kindly pass over this matter.
Why?
Mr. Ghosh is in Lex in court number 2.
Mr. Ghosh is?
He's appearing in court number 2.
Passover, let him come.
Not. Let it be, on Monday, let him be, bring that judgment.
Not today then. Not today.
Wait for Lordship.
Number 83, my lord.
83.
Kindly that thought passover may be given, my lord. The additional advocate general will be appearing in the matter, my lord. He's in, he's on his legs in court number 2.
Yo, yes, Passover, next 84.
Yes, ma'am.
Oh, yes, come. Then give 83.
Next
Give
one
83.
is there before the honorable single right. I'll do that and then I'll do.
So you are ready now?
Yes, I'm ready.
83 give.
শুনেছিলাম আপনার দুই মিনিট এবং বসেছিলেন
Lordship, kindly see your lordship's order, madam. First,
No.
3rd September.
Thereafter, the another order is
Yeah,
passed.
29th January, last order.
Yes.
Yes,
And the deputy superintendent of
Yes,
police was.
he is here.
is
He's here.
directed
He's
to
leading the
personally
SIT.
Present before this call.
He's here. He's leading the SIT. My lord, kindly.
Just 1 minute. Let me go through
Lord,
this order.
No.
Yes, very serious allegations and serious issues.
Yes, exactly, my lord.
Who is representing respondent number 8?
Respondent number 8, you.
Kaushik Bonik. Kaushik Bonik.
And my lord,
You are representing.
Not much to submit.
my lord, subsequent development.
What has
After,
happened?
yes, may I hand over the my lord as for
SIT was constituted and under the direct supervision of the
Superintendent of Police, my lord.
Alipurduar.
Yes, my lord. If you lost
What has happened? Only 64, then there are 2000 something.
my lord, may I
Where the bail bonds,
yes,
bail
yes,
bonds, closed
exactly,
bail
my lord.
bonds.
May I hand over the subsequent development after the lordship? So,
No, not my order.
no, after
this-
the 29th January.
Correct.
Because I filed a report on 28th January, matter
Correct.
was considered it to Devendra Joshi. Well, it is a short list of events I have prepared for a lordship kind consideration.
Yes.
Pursuant to the melody.
Yes.
May I proceed now? Yes.
One.
Yes.
Why? You should take a very, this, you should speed up the entire investigation, not like this. And when you have issued a notice under section 35(3) of the BNSS, and if the answer to the queries which you have raised is not satisfactory, why not you take a very stern decision
may I
and
indicate,
action?
may I indicate difficulties of the to some extent, the SIT, because it is the court premises, the comp.
I understand.
We have made repeated request
Yeah.
to provide two aspects. One is that 64 bail bonds were provided. Two out of the 2954, we have made a request, a prayer, so that the remaining can be handed over, so that it can be examined further. This is number one aspect. Number two, we have made a prayer to the learned district judge when the learned CGM, requesting that the bail bond as of now 5, someone might be had not turned up, or my lord, the trial has commenced. So with regards to that actual situation pertaining to the fake bail bond which was submitted, the status of those bail bonds is required, so that identify that who the persons actually involved in this matter. That also, my lord, twice and thrice we have made a request.
No, you are taking, it will take 10 years time to examine. 64 bail bonds is sufficient to take appropriate action.
May I? There is a, my lord,
How many is the free paper?
my lord, kindly come.
Still appearing every day. Each status report will be paid. He will get the status. The district judge will show the take the report. What time bound identify the district judge is not responding to.
I cannot say the responding, but we kindly see, my lord, our request, my lord. First of all, page 3, my lord. Page 3, we said that kindly provide us the details, particulars for the relevant time at the time of furnishing the bail bond, who are the persons involved. That he has provided the list of that. We have examined that. Now, my lord, difficulty is what happened. These 4 persons at the time of such examination, they said we do not know anything. But my lord, subsequently, the learned CGM, by a query or by the RTI information, provided that the one of the the staff in charge and the 3 staff in charge, they said that Sukhendra Bonik used to come and to lay before the clerk in charge for furnishing the bail bond. Now there is a 2 contradictory statement. May I indicate below?
Sir, the difficulty is they. Sometimes you complain to the ultimately industry for the access to it. Mr. AG, the thing is not that simple.
Yes, it's not simple. It's not simple.
If they say in an RTI that the petitioner or the appellant who came before the court, before him and signed it.
Yes.
The verification of the signature is a very important factor.
Yes.
And the verification of the signature as it appears in respect of 64 is forced one. It does not tally with the signature. So this you have to eradicate.
Yes,
You have to eradicate. What the further steps you took in
yes,
this regard?
yes, exactly. The Malad, what happened, the moment the RTI has come, we made a request kindly because you were saying that he used to come and to furnish the bail
It's not
bond.
that easy that he came and did it.
Exactly, Malad, it is not that.
Not easy.
Malad, last occasion I have indicated, both the persons are involved. It is not that only the appellant or the single-handedly the respondents are involved.
Sir, the difficulty is that when these gentlemen were interrogated.
Yes.
Interrogated by the SIT.
Yes.
They said that they do not know anything about it.
Clerk in charge, initially.
No, this 5%.
Appellant.
These 5 persons who.
Oh, yes. That the clerk in charge. Clerk, that I am saying. Yes.
5%.
Yes.
You interrogated them.
Yes.
They say that they do not know anything about it.
Yes, exactly.
But these 5 persons.
Yes.
According to this RTI.
Yes.
They are one of them, some of them.
All 4.
All 4.
All 4.
They say that he came and signed.
Yes, 48. Kindly come see 48.
So there are 2 things that emerge.
Yes.
Either they are telling lie before the SIT or
Yes.
they are telling lie before the
CGM, blood CGM.
CGM.
Yes.
If there is a disparity, why don't you take steps? You are within your rights to take a step.
Malad, that is the Malad, kindly see the page 49.
What was the RTI which you filed?
Yes, yes.
What was the RTI? What is the
That-
questions?
Yes,
Information you
Yes,
said?
yes,
Where
ma'am.
is that?
Yes, page
You
40,
have-
page 40.
You have given simply a reply.
No, I have
to-
not given.
You have annexed the reply.
Yes,
I
yes,
just
yes.
wanted to know what are the queries which are.
Yes,
there.
Bilal.
Where is the application under RTI?
Malad, kindly come to page 45. Yes, your RTI. None.
45.
45, Malad.
Yes. This is the RTI of 4.3.
Yes. Malad, this is the
What you wanted according to the RTI?
according to I have wanted the number 1. According to the RTI reply, provided it seems that Sukhendranath Bonik used to personally come into
No,
pit.
that is after this.
What is the RTI's Malad?
RTI application for what is the reply is annexed at page 5.
Malad,
You have annexed the reply at page 5.
Malad, I'm just a second, Malad. Just a second. I'm just. No, 5.
No. 5 is something different.
Yes, that's why it's not
No,
mentioned,
no,
not
it's
5.
not. Where is the RTI
That Malad,
reply?
My RTI bill, I have one copy with, which I.
Sir, you are not Anirban Majumdar.
Since one RTI bill, which I have.
Sorry, the Anirban Majumdar had said that.
That is on the basis of the reply we
The
received.
reply, where is that reply?
Malad, I am giving just a second, Malad. I just no. Huh?
Oh, that is at page 10.2. That is at page 7. Dated 10.2.
10/2/2025. No, this is to Anirban Banerjee. No, Malad. No, Malad.
No, this was
But
given to
I'm
Anirban Majumdar, who is a inspector of police. At
No,
page
no,
7.
Malad. Yes, Malad. Applicant.
This is a reply given by this is a Kaushik Boni, that's respondent number 8.
8. Malad, may I hand over? This is the Malad. I have a copy. I think I did not annex. Malad, kindly I have a one copy. Malad, it has not been perhaps. Malad, can I seek up to 5 minutes accommodation, Malad? 5 minutes. I will, because I have annexed it, I have seen it, Malad. Give me a 5 minutes, I'll come back. So that I can give you a proper assistance, Malad. Because কোথায় এটা ছিল তো কালকে আমি রিপোর্টে দিয়ে দিলাম তো
Anyhow, then come at 2 PM and then prepare.
Huh?
My lordship, it's my, it's a prayer on behalf of the appellants, my lordship, and the daughter of the appellant, my lordship. To, my lordship, can I submit in Bengali, my lordship?
What you want to say,
My
we
lordship.
are fixing the matter at 2 PM. Let them come with all the, let us understand that what has happened. If there is a progress, there is no progress, or there is a progress in slow pace, we will see that how it can be done.
My lordship, I want to submit something on behalf of the appellant's condition, life condition, my lordship.
Madam, you have flagged an issue. I mean, you means your father has flagged an issue,
Yes, my lordship.
which is a very serious issue.
Yes, my lordship.
We cannot let it go so easily. So we are in a process of unearthing all the things which are there.
Yes, my lordship.
So your cooperation, your assistance is only required. You are simply an informer to us. Let us take what steps we have to take against everybody.
I want to submit one thing regarding the police protection granted by this court on earlier order, my lordship. My lordship, this police protection has been ordered by coordinate based. My lordship, can I submit in Bengali, my lordship? My lordship, 21 জানুয়ারি 2025 যখন কোঅর্ডিনেট বেঞ্চ এর আগে অর্ডার করেছিল, ফার্স্ট উনি এই কোঅর্ডিনেট বেঞ্চ পুলিশ প্রোটেকশন দেন আমাদেরকে, আমাদের কন্ডিশন শুনে জাস্টিস জয়মাল্য বাগচি ছিলেন উনি, মাই লর্ডশিপ, উনি আমাদের কন্ডিশন দেখে দিয়েছেন। আমি ওনার কাছে ক্লিয়ার করিনি, ইভেন আমার ক্যান 3 বা ক্যান 2 এর মধ্যেও আমার পুলিশ প্রোটেকশনের জন্য কোনো প্রেয়ার নেই। মাই লর্ডশিপ, এটা দেওয়ার কোর্ট নিজে থেকে দিয়েছে একটা কথার জন্যই, যে ওনারা আমাদের এগেইনস্টে, ইভেন আমার একটা মাই লর্ডশিপ অ্যাপিলেন্টের ফ্যামিলিতে 4 জন মেম্বার, আমি মেয়ে, অ্যাপিলেন্টের ওয়াইফ আছে, আমার মা, আমার একজন ভাই আছে, সে মাইনর 13 ইয়ার্স, ওর এগেইনস্টে দুটো কেস স্টেপ করতে না করতে 13 এসসি এসটি অ্যাট্রোসিটিস এর মামলা, আরো নানা রকমের খারাপ মামলা মাই লর্ডশিপ। এই জিনিসটা শোনার পর পুলিশ প্রোটেকশন দেয়, সেই পুলিশ প্রোটেকশনটা 24 তারিখ থেকে ওনারা আমাদের ওখানে দিয়ে দেয়, কিন্তু সেই পুলিশ প্রোটেকশন মাই লর্ডশিপ পরশুদিন রাত 7টা নাগাদ আইও মানে আমাদের যে এই ম্যাটারের ইনভেস্টিগেটিং অফিসার আছে আমাদেরকে নোটিশ করেন যে একটা ইনভেস্টিগেশনের থ্রু আপনাকে ডাকা হয়েছে। গতকাল সেটা বিকাল 5টার সময় ডাকা হয়েছিল, আমরা থানায় গিয়েছি, জাস্ট পৌঁছতে আমার মা আর ভাই আমার বাড়িতে ছিল, ওনাদেরকে বললেন যে আমাদের উপর থেকে অর্ডার আছে, আমরা পুলিশ প্রোটেকশন তোমাদেরকে আর দিতে পারবো না মাই লর্ডশিপ। ওখানে ওনারা না থাকা আর এই অর্ডার কোর্টে না সাবমিট করে ওনাদের চলে যাওয়া মাই লর্ডশিপ, আমি এটার কারণ কিছুতেই জানি না।
Why the police protection is withdrawn just when why police protection is withdrawn abruptly?
It has not been withdrawn, my lord.
She is saying that it was withdrawn.
My lord, kindly, which order you are referring? My lord, may I have some objection before that? My lord, here, under the, my lord, the Advocates Act, petitioner, appellant before your lordship is an advocate. He can be represented in person.
Forget about it.
No,
When-
my lord, everything cannot be.
No, order
my lord,
3, if you talk about, then order 3, rule 2 permits any authorized agent to represent. There is no difficulty. If a person who cannot express so
Then he will-
because
he-
of being out of touch for a long time. No, Mr. AG, I will not. Just tell me, if the police protection was provided, then why abruptly police protection was?
my lord, which order she
withdrawn?
is referring, my lord?
She is referring a 21st
21st order.
or
21st order. 21st, your lord, just a second. Just a second.
So why
You
abruptly?
must, just a second, my lord,
You ask me, Ayo. Whether
it has not been withdrawn, my lord. Just, it has not been withdrawn. I'm with
Straight away, then, if it is
Okay,
not
okay.
withdrawn, that will
Okay.
continue, she has said.
which paragraph?
My lordship, SDPO sir has just said, my lordship, yesterday, my lordship, evening. and
You don't have to point it out. I am here, I'm assisting the court. Which paragraph? Which paragraph?
Mr. AG,
My lord.
after all, they are the private litigant. Please, at least you are a very responsible officer of the state. You have no inclination for anybody.
Anyone, no inclination.
You are absolutely, I absolutely, I was going to use a very bad word.
No,
I'm not-
kindly use, my lord. So that it will be for our lesson. I will not mind for that, my lord.
No.
Kindly rectify me.
So
But my lord,
I do not
difficulty is
want
because
to
I may
open-
to
I
some
do not
extent
want
had
to
lost my
open
temper.
any kind of a thing, anyhow.
কোন
You
paragraph?
have to be very, very, very neutral only in pursuit of justice. That is what is also the important role of AAG, that he is the crusader of the justice.
Well, this is
This is what he should.
which 21st of January, where this order?
I mean, who harbingers the judge, the justice. We should uphold the justice.
But I am, Milord.
I may have used the wrong expressions. I do not know. Order sheet दाओ तो देखिए 21st फाइल तो दाओ
21st January, Milord, I
21st January order. Let us see whether order sheet.
My lordship, one thing I want to say.
Just 1 minute, madam. Slow.
There is nothing.
Yes.
Okay. Yes, Milord. Page paragraph 30. Paragraph 30. We further directly.
Yes. Yes, paragraph 13 to the appellant and his family members. So this was directed.
Milord, as
So why he says that it has been abruptly
Milord, police
withdrawn.
protection was given, not police posting.
No, it's
Police protection.
What is the meaning of the word?
Police protection every time, Milord. So
What?
We can
When
clarify.
the crime is already committed, then the protection would be extended, or it is to prevent any kind of a recurrence of a crime. Why it was given?
Milord,
It was given because there has been a series of the complaint or the cases being initiated against them because they have flagged this very serious issue. So that for that reason, the court says the police protection means what? What protection?
Protection means, Milord, we have protected her or the family. Milord, from the GDA it will be reflected.
By creating a wall around their property. How you have given a
Milord, the mobile van were posted, 2 mobile van.
Mobile vans at a different intervals that goes.
Not only different intervals, Milord, in hourly basis, Milord.
So in fact,
Now,
I will-
between these hours, if
Yes.
something is reported, then what?
But the police protection and the police
I'm
guard.
simply asking because
No, the police.
one has to understand the meaning of a word in juxtaposition with the events which is recorded just prior there. The police protection has to be understood from the context and not in an abstract manner.
Understood, Milord. But Milord,
The context which we find was that they were saying that taking advantage that this out of this, since they have flagged a very serious issue, and it appears that their allegation is not absolutely false, because there has been certain materials which was unearthed, and it was found that there was a fake or a forged security or documents, their signatures were forged, which was appearing from the record. At least 64 cases have been found.
it is the case, Milord, in other way.
Now,
Milord.
one is the proficient member of the profession. The court has made certain observations regarding the member of the profession.
Yes.
And then says the police protection.
Yes.
That means that the police must be there round the clock.
So it's not, they ought to have been, police guard ought to have been posted.
Posted. We are directing you to post the
Milord,
police
Milord,
guard
kindly, there must be,
24/7.
Milord, there must be some appreciation of the threat, Milord, threat.
There are series of
There must be, our
the criminal cases.
Our intelligence report says there is no such perception of threat, Milord.
We can't appreciate it.
Milord,
And
kindly,
the moment
Milord,
we
as
find,
of now, is there any incident? As of now, because they are fighting, Milord, 4-5 years. As of now, any incident took place with regards to their
Tell me, the-
their life or the
what-
personal liberty.
After 21st January 2025, is there any other cases which is filed against you in the police station?
My lordship, not, but
Not.
before the 21st, 2 days before.
That is what is, we are not concerned. We are concerned with 21st when you say that they have they taken off those police from your house for that reason. Got it.
So no,
We'll see.
no,
We'll see what to do.
my lord, that always your lordship can. But there is, my lord, as of
We'll
now,
see too.
we have protected the family members, including the members of the bar, and also we have protected the other, my lord, the general public even. There is no iota of incident happened in the Alipurduar district since last couple of years even.
My
No,
lordship,
that's good. That's good.
So that's why we are protecting.
That's
Even,
the-
my lord, suppose,
that is
may I
the-
say?
I think that is the primary responsibility
That is the-
of a police
Exactly.
administration
My lord, may
to
I?
maintain the peace and the I would
Exactly,
say
my lord.
tranquility there so that there may not be any kind of a.
My lord, suppose now.
Yeah,
even-
we appreciate, but considering this.
But my lord, suppose now the police guard is posted 24 hours. There can be anything, we cannot say that nothing can be happened even, my lord. Despite deputing the police guard,
Then at least,
posting even.
at least it is his.
Then
duty.
Rajiv Gandhi wouldn't have been, my lord,
It is his
assassinated despite such a security.
You are
Then
raising an issue which is.
You will be held
everybody is
responsible for
watching,
that.
is
My lord,
watching live.
my
We
life
do
even
not
is
want to
under
make
threat.
any comment.
My lord,
You are live, sir.
You
You
have
do not
forwarded
want to
this.
make any comment on these instances.
my lord, but the intention of the, my lord, this order of the 21st January, my lord.
So it is a order of the court, suo motu order. They did not pray for police help. This is the order of the.
No, on the
order
basis of the
court.
request, my lord. On the basis
I
of the
did not
request.
find. I did not
Otherwise, the police, how my lord, the court will come to know they are under the threat.
The
There is
order of
no
the
such
court.
event of iota of evidence
Sir,
as of now because she
Then-
said no.
It is your
Then-
duty to
then-
respect the
then-
order of the court.
Then I am.
But I am respecting. I have not violated. I have protected, my lord.
But we thought
No,
it-
nothing, no injury even, not a single injury happened, my lord.
Mr. AG, that I am inviting your kind attention to the several observations of the bench.
Yes.
Made on 21st of January 2025.
Yes.
Right. I am just inviting your attention to this. Paragraph 4, if you can come.
My lord, I'm coming.
Please. Why the court granted a police protection was because of paragraph 4.
Yes. They submit. It is that is their submission.
I understand. But once the submission is made before the court in the hindmind takes that into an account and then passes. Then what is the role of a lawyer? The lawyer's role is to argue and make submissions before the court. And the court can ignore those submissions.
No, my lord.
Cannot.
This is the reason
So-
paragraph 13.
I am telling you, sir, this was there. The court has found that there has been a systematic harassment by way of filing a criminal cases against them. And for just to arrest that this is not record, says that the police protection must be rendered.
All right, my lord, I am
immediately.
not because if your
This
lordship,
is the reason for granting a police protection, otherwise no police protection.
all right,
was
lordship,
given
your
to them.
lordship did
So
that.
that there is no recurrence of any
So,
false
Lord, the
criminal case
police
against them.
protection, it is in our mind
Now-
that initially, my lord, police personnel were posted. Because of the shortfall, my lord, we have lifted that, but constantly, my lord, we are keeping a constant
Anyhow, we
visit.
will say that what should be done.
Yes, my lord, that we will do. My lord, now I have got that paper, my lord, that is which I was indicating, my lord, the RTI,
Where is that?
page 35
Of what?
of my that short events.
The
Today's
compilation.
list of events. Yes,
The-
compilation.
Page
35, my lord. 35.
The reply.
Yes, sir.
Yes.
My lord, this was
Just
the-
1 minute.
Yes.
So,
Question
so
number
your,
7.
your question number 7, that is
Yes.
what is the relevant.
Exactly. I have
So-
asked that. Question number
There
seven
is
is-
a factual aspect which is not information. How facts can be given this type of
that is
answer?
our query.
That
Sir,
is different.
the difficulty is that there was no webcam, there was no CCTV camera at the relevant point of time installed.
This question
If
cannot
he
be asked.
says that he used to come personally and furnish a bond, then in that event, you have integrated the clerk in charge. What was their, according to you, their stand was that they do not know anything, they were not in the helm of affairs. Now the question is then who was the judge in clerk, I mean the clerk in charge, who was in helm of affairs? One thing you have to find out as an SIT. The system cannot run without a man being posted at that post. Can it run? Then there must be a clerk in charge. Then the gentleman who has said, I do not know, may not be a clerk in charge of that relevant point. Then
No,
who
he
is who else?
judging clerk. Kindly come
Then
36.
who else during
Page
those
30,
periods?
Page 36, kindly come, page 36. 36. Then that was my prayer, page 36.
What?
That kindly provide the RTI reply.
Sir, very interesting. Question 5 was, please come to page 35.
Yes,
Very,
yes. Page 35.
what was the question? Question number 5. When his surety has been terminated and why his terminated, I do not know which English, terminated his surety. Please mention the date of termination of surety. The answer is, his surety had been suspended on and from 21/9/2022 on the basis of the prayer made by Sukhendu Nath Bone. Then come to page 36 of your inspector in charge. What he understood from this answer.
No.
This
Point
Anirban Majumdar is.
number 7. Point number 7. Kindly see point number 7. The report. I have sought for a report.
Mr. AG, I am very patient in listening you. I think I expect reciprocation. Please come to page 36.
Yes, 36.
Please come.
Yes.
Just first
Yes.
paragraph.
Yes.
According to the reply provided on 21/2/25,
Yes.
for the question number 5,
Hmm.
it seems that the Surendranath Bonik's surety has been increased.
Yes.
I just wanted to know where from you get in answer of question number 5. Increased.
Suspended.
Increased means what? That
Value has
he
been-
must have given a surety of 5 lakhs, it is increased to 7 lakhs.
Amount.
From the report of the that I
This question number, that's why I invited your attention, sir. If you do not understand the question and the reply, and then you give it, that means you are not competent to do so.
But initially the surety capacity was 50,000.
I understand, but this was not reflected anywhere.
Was not reflected from the.
Then how you say question number 5 that it has been increased? It appears. You say,
Terminated by the date and time of the.
correct. You did not ask for any increase. Then he say it is suspended from such and such on the prayer of such and such. That's the answer.
Yes.
And then you say, according to the reply provided for question number 5, it seems that his surety has been increased.
Take instruction.
How?
Page 36, it is not the pursuant to the RTI reply.
Yes, then
Page
which?
36 is not the pursuant to the RTI's reply.
RTI's reply. So it is
Because
not.
RTI reply was 11th February 2025.
Correct.
And
Because I could correlate because it was, reply was dated 11th February and this was written on 3rd March. So must be in a close proximity of time.
Reply provided on
second query, with regards to the RTI.
21st February, there is a.
Yes, 21st February.
Where is that? Where is
Why
that,
is that?
sir?
21st February.
So you are not ready.
21st February কোথায় লেখা আছে? না না কোথায় লেখা আছে 21st February? Reply provided on 21st February. Must be it is of 11th February provided on 21st.
Yeah, it is.
If I just point this out, subject to and commission, this RTI was not preferred by the police authority. My client wrote this RTI application of which he received this reply.
Whatever.
Now, when we received an application under the notice under 41A, in reply to that notice, I had submitted this reply to the police authorities that this is what I asked for, this is what I have received, along with my statement.
So you should have enclosed that.
This is the.
You should have enclosed before that, page number 36.
May I kindly see 21st, this is the CGM has provided to the investigating officer.
Which page?
Kindly see, I.
It is not annexed.
Why is not annexed? Prior to page number 36, it should be annexed. Take instruction. You can have the public now, updating that.
What is the stage of the investigation? Tell us. What is the stage of the investigation? What are you doing? What are your problems in the investigations? Tell us. We will pass the order. Unnecessarily, we will not go into all these nuances. Everything will be opened. Further troubles will come. We wanted at least to end with the logical conclusion.
Kindly, it is annexed, not annexed in. Annexed in.
What?
Page number. Yes, or.
Yes.
This is not the process.
Yes. Okay, 18 below. Page 8.
I'm just trying that you are submitting a report. You are doing something in terms of the order passed on 29th of January. You are supposed to submit a report showing the progress. Showing the progress.
Yes.
What is this? Then
Must be present.
what is the last?
Last order.
Must be present. I report on the name. Yes, further report. Further report, let the matter.
What the report to this put on the adjourned date? Paragraph 11, sir.
It is checked.
Sometimes we have to. Paragraph 11 of that order. Oh, this is of 21st of March, January, sorry.
29th January.
Sorry, I'm just.
The 29th January.
Yes, the report,
Yes,
for the report to be filed. Paragraph 15.
Report by superintendent
So-
is the adjourned date.
Correct. So this is the adjourned date.
This is the compilation. This is the compilation of.
It's a copy cut date.
Have you submitted any report or not?
Compilation of progress report.
Have you submitted any report today?
Yes, which I have handed over.
Oh.
Which I have handed over.
399. It is of 11/9/2024. It's a letter to. It is the district judge se case che. No, we do not want the district judge. We wanted the superintendent of police report.
Further report by SP. This has been written.
File a report.
Sir, we have to file a report.
Compilation of the progress.
So you are not
We'll have to
complying.
file a report that what are the problems What you have done, everything is to be done by the SP. This can't be done.
Further report by Superintendent of Police.
File it on Monday. Yes. It
84.
चलो चले जाओ continue anybody is appearing
Mr. Navankul Pal is for this petitioner. His mother passed away 4 days. Not two
next circuit এই নবাঙ্কুর পালের যে অর্ডার আছে না it's called the next
85.
but do one thing today is something exceptional so I am not passing any order we'll call it is next
86.
just go on call it just call it
87.
Lordship, I appear in 87 for the petitioners, Lordships.
yes there is nobody other side
Lordship, it's the GST matter and
if anyhow other side is not here let us see pass over
grateful, dear Lordships.
88. 89. 90.
Navankul Pal's matter.
91. 92. 93. 94. 95. 96. 97. 98. 99. 100.
100 minute, I beg to appear on behalf of the appellant before your lordship.
but there is no other side madam
Milord, I am waiting, milord, your lordship kindly takes it up today, milord.
okay let us see yes call the next
Grateful.
102.
I am for the appellant in 102 milords. I would be requesting milord if this matter can be given some preference on Monday.
we'll see to it we'll see
It's
to
an
it
urgent
don't
case,
worry
milords.
we will start from the today don't worry
103.
My lord, 103, my lord, I beg to appear virtually, my lord. I am for the petitioner, my lord. This is GST matter, my lord.
but there is no other sides
My lord, may I pray one thing, my lord? The matter may be fixed, my lord, on Monday, my lord. If your lordship,
it's simply a passover don't worry yes
my lord.
105. 106. 107. 108. 109. 110.
110, my lord, I am for the respondent number 6, my lord. On the last occasion, there was a direction to file our opposition against the restoration application. My
the
lord, we have,
appellant is not here the appellant is not here let us
my
see
lord, one indulgence, my lord, kindly extend some time. We need
we
some
will
time.
we will extend when the appellant is in their presence we will extend don't worry
Grateful, lordship.
next
111. 112. 113. 114. 115. 116. 117. 118. 119.
Well, item 93.
yes
Well, item 93. I think it has been passed over. Well, I appear
there
in
is no
support
other
of the
side,
appeal.
sir. There is no other side who's appealing let it be taken up Monday
Very well.
আজকে যেখানে শেষ হয়েছে means 83 তে ওখান থেকেই start
Oh,